The broadcast is now starting. All attendees are in listen-only mode.
Good morning.
Okay, I've got you on audio on my phone and video on my computer. Can you hear me and see me?
We can, Megan, so we're good. So looks like we got our technical problem remedied. And Megan, while you were logging back in, we admitted everybody to the conference. So they're before us, and I'll make an introduction and then turn it over to the two of you. So great timing. So good morning once again, ladies and gentlemen. I'm Marty Fatanti with InvestUP. Thanks so much for joining us with this webinar with our good friends from Miller Canfield. We really appreciate their continued partnership through this COVID crisis and lending their expertise. I want to especially thank their managing partner, Mike McGee, who's just been a tremendous resource and tremendous friend of the Upper Peninsula throughout this crisis. So really grateful for their continuing assistance as we try to understand what some of these legal requirements are and what those implications look like. I also want to take a minute to thank our friends, Amy Klickner and her team with the Lake Spirit Community Partnership. They too have just been a great resource and great friend throughout this crisis, and so glad that they were able to partner with us again to bring this content to you. Today we're going to do questions a little bit different. Megan, Norris, and Nhan have got a presentation that'll run about 40 minutes. We have an hour set aside, but we've gotten some advanced questions, and they've also tried to anticipate some questions that they've worked into the presentation. But if you have additional questions, please use the question pane, and we will make sure during that last 20 minutes that we address any questions that they were not able to work through in advance in their presentation. So with that, it's my pleasure to introduce to you Megan Norris. Megan is been representing employers for 3 decades. She's an accomplished litigator who's been elected by her national peers to both the College of Labor and Employment Lawyers and the College of Trial Lawyers. Megan has expertise litigating all matters of employment law. She's tried over 30 cases, including matters in Michigan's circuit courts, the U.S. District Courts for the Eastern and Western District, the U.S. District Court for Northern District of Illinois. Megan's been the recipient of many honors, including the State Bar of Michigan Labor and Employment Law Council Distinguished Service Award, and was named Best of the Best Lawyers in America 2019 Detroit Employment Law, as well as the Management Lawyer of the Year. Megan received her JD from the University of Michigan. We're also grateful to have Nhan with us. She's an associate at Miller Canfield. Her practice concentrates on employment discrimination, leave rights, wage and hour litigation, and disputes. She regularly counsels employers on their policies and practices to address specific challenges in the workplace. Nhan was previously an intern for the U.S. District Court for the Eastern District of Michigan. Nhan is currently a member of the Equal Employment Opportunity Committee and is an American Bar Association Labor and Employment Law Section Young Lawyer Division Fellows Program participant. Nhan received her JD from Wayne State University Law School, where she graduated magna cum laude. Ladies, thanks again for lending us your expertise and your time today. And with that, I'll turn it over to you.
Terrific. Well, thank you very much, everybody. We're going to be covering some general things and some very specific things in the short time that we have this morning. So Nhan is going to start off by talking about some of the key places you need to look for information. And I will preface this by saying this is a target that is constantly moving. The CDC guidelines change all the time. The regulations and guidance from other organizations change all the time. And we now have a court that has said that some of the regulations are unlawful, and it's not clear what's happening with that. So some of this is very specific, but you should know that it changes, and you should keep your eyes open. We'll then talk about some of the back to work issues, what you need to do to get ready to bring people back to work, what you need to do to make sure that you have a safe workplace. And then we'll be spending the rest of our time talking about the very complicated issues arising out of your employees who maybe can't work or don't want to work or want to work from home or need to work from home, and how that interplays with all of the laws, both the new COVID-19 laws and our regular ADA, FMLA, those kinds of laws, where that fits in with all of that. So to start, Nhan will bring us up to date on the key guidance and regulations.
Thank you, Megan. So returning to business is, of course, dependent on whether you can meet the safety and health standard that is imposed by the government guidance and directive to prevent contamination and spread of COVID-19 in the workplace. Like Megan said, these guidance are constantly changing, not monthly, but now it's like weekly and daily. So you need to keep yourself updated to this guidance. We are going to talk about some of the specific guidance here, but of course, you have to be sure that you can keep yourself up to date with this. First of all is the executive order by the Michigan governor. The most recent order that you should be aware of are the order number 160, 161, and 166. Order 160 is the latest amended Safe Start order. It provided work requirement. It revised the limits on social gatherings, and it details what type of business can reopen depending on the areas. Michigan Northern Region 6 and 8 have lesser restriction than the rest of the state, so you should keep that in mind as well. Order 161 provided an update list of the safeguards for reopening workplace generally, and also contained specific COVID-19 rules for specific type of industry. And then Order 166 provide protection for workers who need to stay home when they have COVID-19 or its symptoms, or when they have come close contact with individuals who have COVID-19 or its symptoms. So currently, it would be unlawful in Michigan to not allow an employee to stay at home when they have COVID-19 or its symptom, or come in close contact with somebody who have COVID-19 or its symptom. Then you should be aware of the local public health orders. If you are in one of the cities or counties with their own local health orders, you will need to be aware of them and abide by them. So what you should do is contact your local health department to see if they have any order that are or might be applicable to you. Then you should be aware of the guidance from the CDC. The CDC has several important guidance for employers and business, including what safety measure opening business should implement, what to do when a worker is exposed in the workplace, and how to properly clean and disinfecting your workplace. You should also be aware of the guidance from the Occupational Safety and Health Administration and MIOSHA. So these two entities work together to provide a safe workplace for employee. They have several guidance that are important. One of those is the guidance on preparing workplace for COVID-19. Reopened business are required to prepare a preparedness and response plan in accordance with this guidance. Then you should be aware of the guidance by the Department of Labor. The Department of Labor is the one that implements the Family First Coronavirus Response Act. It had a website that is dedicated to that, including what regulation that are available to implement this law. It also includes a fact sheet, question and answer about this law. So you should definitely consult with this resource if you have any question about the Family First Coronavirus Response Act. And then finally, you have the guidance from the Equal Employment Opportunity Commission. They have several resources concern equal employment opportunity laws and COVID-19, including what is the relationship between leave and the American with Disabilities Act. Megan will talk more about this, but you should definitely consult this if you have somebody with health issues that don't feel comfortable coming to work. They have several resources, might be very helpful to you. And then the next step is pre-reopening preparation. Aubrey, if you can just move the slide, we're like a few slides ahead now. Yeah, keep going. Keep going.
And Nhan, as she's doing that, can you tell us, will the presentation be available afterwards that we could share as well?
Right here, we'll stop right here. Thank you. Okay. Okay, Megan, you're good. Okay, we lose Megan's voice. Megan, you're on mute.
And Megan's trying to work that out. We have the presentation, I'm told, and so we will distribute that after the conclusion of the webinar as well, so that the participants have the actual presentation.
Yes, yes, that would be great. Thank you. Okay, I think that has some issue with her audios.
Yep.
So, yeah.
Part of the challenges of today's new world, right? So.
Right, and sometimes, you know, the internet doesn't do what it's supposed to do.
Sometimes computers don't do what they're supposed to do.
Am I there?
You are.
Okay.
Yeah.
All right.
Welcome back.
All right. I got kicked out. Okay. So yes, the slides are available for anybody who wants to see them. So now you want to bring people back to work. And so what do you need to do? The first thing is you have to figure out who is coming back to work. Sometimes this is really easy. You're opening up your entire workforce and everybody's coming back to work, and that's simple. But a lot of times it's not. Many organizations are going slowly, bit by bit. So they're starting with people that they just have to have on site because they can't do their work on site. You can't fix equipment if you're not on site. You can't teach a student if you're teaching, if the student's supposed to be there and you're not on site. And then gradually bringing back more people as things get settled down. So you have to make that decision. And the key there is to think about really what you need and then make the decision in, of course, a non-discriminatory way, just like you would anything else. So you have to have a thoughtful process for how do we decide who's coming back. And it can't be, we like Nhan and we don't like Megan. It has to be, we need Nhan for these reasons and we don't need Megan for those reasons. So once you do that, then before they come back, and this should be starting now, if you're bringing people back in September, it should be starting at the earliest opportunity. You have to figure out how you're going to prepare your workplace for them to be there. There are things that you need to do before they come, and Nhan's going to talk to you about those.
So before reopening, the first thing that you need to do is to make sure that your facilities and everything within it are clean and disinfected. You should check the building to see if it's ready for occupancy by ensuring that the ventilation in the building is operating properly. Ensure that you can increase the circulation of out airs in the building. And then you should evaluate the building and its mechanical and life safety system to determine if the building is ready for occupancy. Then you should conduct a thorough hazard assessment of the workplace to identify potential workplace hazards that could increase risk for COVID-19 transmission. You should reconfigure your worksite to limit exposure risk and ensure compliance with social distancing protocols. In other words, you should implement measures to make sure that worker can remain 6 foot social distancing whenever possible, such as realigning the workstations so then the workers are at least 6 feet apart. You should identify, limit access, or reconfigure the common areas in the workplace where workers would have close contact with each other to reduce crowding and ensure that the 6 foot distance can be maintained. And then you should use signs, tape marks, or other visual cues to indicate the worker that they should maintain social distancing, that they should stand far apart when physical barriers are not possible. Then you should implement methods to prevent unnecessary contact by adding, if you have worker that's clocking out and out physically, then adding additional clock in and out station that are spaced apart to reduce crowding in these areas. You should replace the high touch community items like coffee pots, water coolers. If you have snack laying around, you should limit that. Then you should place hand washing station or hand sanitizer in multiple accessible locations in the workplace to encourage the employee to hand washing and keep themselves hand sanitized. You should ensure adequate posted of signs to remind the employee to hand wash, to social distance, and what to do when they have COVID-19 symptom. And then before reopening, you should ensure that you stock sufficient supplies of cleaning materials, disinfectants, face coverings, gloves, and so on to provide to employees before when you reopen. And then what you should implement safety protocol once the employee come back, or before the employees come back. You should prepare and implement safety protocols to, when the employee return to work. The first safety protocol that every business are required to do right now is conduct daily screening of the workers. This includes a daily temperature checking, as well as requiring the employee to answer questions about symptoms and travel history. If you decided to conduct daily screening physically or in person, you must make sure that you implement safety protocol that protect the screener, such as installing barrier or partitions, provide them with adequate protective equipment. In this case, masks alone is not enough. You have to provide them with better equipment. The information that obtained from screening must be kept confidentially because they are medical information. Then you should have a policy in place that encouraging the employees to stay home if they are sick. So you should, encourage them to use available option under your policy, such as remote working, take leave that is available under your policy. You should also have in place a protocol for enhanced cleaning and disinfection of the workplace. Regular cleaning during this time is no longer sufficient, especially if there's a case of COVID-19 in the workplace. Cleaning and disinfection is especially important. Then you have to have a protocol for in the event that there is a report of a confirmed or suspected case of COVID-19 in the workplace. I will talk a little bit more about what other steps that need to be taken, but you have to have a protocol like that in place. Then you must make sure that the employee are adequately trained on the safety protocols that's set out in your response plan and the new policy that you established during this time. You have to make sure that you update your employee if there are any changes in the policy. As we know, there's a lot of changes in the directive, so there would be a lot of changes in the policy, and you have to keep communicating with your employees. And then you must make sure that there is a supervisor on site or a designated person on site who is in charge of enforcing protocols, and from whom your employees can ask questions about the protocols. Just a quick touch about what to do if somebody is sick in the workplace. If the individual who is sick is present in the workplace, of course you should immediately separate the person and arrange for him or her to go home. If the individual is not in the workplace and they just call in to report that they are sick, you should direct them to stay at home, to self-quarantine, and then to ask them to follow up with a medical professional and follow their guidance. Then once you learn that there has been a case of COVID-19 in the workplace, you need to take steps to identify potential exposed individual and areas. So, who the person have come in close contact to, where area have they been in, and stay long there. And then under the Michigan governor executive order, you are required to immediately notify the local health department. And then within 24 hours, you must inform the close contact of the potential exposure. And then you should close off the potentially impacted areas and perform cleaning and disinfection of the area. You should also, keep in touch with the infected individual and inform him or her of the criteria for returning to work. All of these safety protocols and guidance, we are having an HR spring training upcoming in September 9th, and all of these will be discussed in detail in those seminars. So if you are interested in hear more about all of these safety protocol, sign up with us to attend the HR spring training. All right, and then the next part of our webinar is the leave issues during COVID-19 pandemic. We are going to talk about what type of leave are available, and then we are going to, show you how to apply this law with the issue that you have. So the first leave that are available is the family First Coronavirus Response Act. This is a new legislation that has been implemented by Congress to provide employee with fewer than 500 employee with leave due to COVID-19. It is only in effect from April 1st, 2020 to December 31st, 2020. So we only have about 4 months left of this leave. There's two different types of leave under the Family First Coronavirus Response Act. The first one is leave provided under the Emergency Paid Sick Leave Act, which gives the employees up to 2 weeks of paid sick leave if the employee is unable to work or work remotely for one of the 5 main qualifying reasons. One is if the employee is under a order related to COVID-19, such as a shelter-in-place or stay-at-home order. The second reason is that the employee has been advised by a healthcare provider to self-quarantine because of COVID-19 public emergency. The third reason is the employee is experiencing COVID-19 symptom and is seeking a medical diagnosis, but leave can be only provided for the time spent taking affirmative step to seek a diagnosis. The fourth reason is if the employee needs to care for an individual who's subject to a quarantine or isolation order or advised by a healthcare provider to self-quarantine for COVID-19 reason. And the fifth main reason is that the employee is caring for a son or daughter whose schools or place of care has been closed or the child care provider is unavailable due to COVID-19 concern. Then the second type of leave under the Family First Coronavirus Response Act is leave provided under the Emergency Family and Medical Leave Act, which provide employee with time off to take care of a child whose school or place of care has been closed due to COVID-19 concern. You can get up to 12 weeks of leave, but this is the same length of leave from the Family and Medical Leave Act. Megan will talk more about this, but there's only one qualified reason to take this leave is to care for a child whose schools or place of care has been closed due to COVID-19 concern. Leave under the Family First Coronavirus Act are paid leave, and the payment of leave would depend on the reason that leave was taken. So for some of the leave, payment would be in full, and some of the leave payment would just be a part of what the employee usually paid for. The employer will receive tax credit for payment made to the employee for leave taken under the Family First Coronavirus Response Act. The Department of Labor has implemented regulation to administer the Family First Coronavirus Response Act, but there has been recent decision by courts overturning some of these regulations. Megan will go into more detail when she discusses with you how to apply this law. And then the next leave that's available for you is the Paid Medical Leave Act of Michigan. So this law has been implemented since last year and is require employers that employ 50 or more individuals to provide eligible employees with up to 40 hours of paid medical leave. Eligible employee normally just include non-exempt full-time employees who work on average more than 25 hours per week. There are also many exemptions from the definition of who can be an eligible employee. There are many reasons that an eligible employee may take paid medical leave, but 3 of those are particularly relevant. One of them is closure of business due to a public health emergency. The second reason is to care for a child whose school or place of care has been closed by order due to a public health emergency. And the last one is that the employees or his or her family has been exposed to a communicable disease that would jeopardize the health of others. So those are the 3 reasons that is particularly relevant during COVID-19. The requirement to provide paid medical leave usually have been satisfied with leave benefits provided by the employer in their policies, but we just wanted to mention this to make sure that you're aware that there are legal obligations exist to provide leave under Michigan law. Then I'm going to turn to Megan for the other type of leaves. Okay, Megan, you're mute again.
myself.
Okay.
All right, we have three other kinds of leave that you're used to. These are what I'm going to call regular non-COVID-19 specific leaves. First, we have the regular Family Medical Leave Act. The Family Medical Leave Act covers serious health condition of the employee or the employee's parent, spouse, or child. Not all COVID-19 matters will be covered by the FMLA. For most people who have COVID-19, and I've had 5 people in my family with COVID-19, and for 4 of the 5, they never saw a doctor. They got sick. They might have called a doctor on a phone. Doctor might have said, that sounds like COVID-19. You need to stay home until you're better. Or they might not have even called a doctor. They might have just known these are COVID-19 symptoms. I'm sick. In my family, folks got it early when the hospitals were full and the doctors weren't in their offices. So, you know, you just sort of muddled through. That's not protected by the FMLA because a serious health condition requires either a chronic or long-term kind of condition, or it requires something where you see a doctor and you see a doctor either twice or once with a continuing course of treatment. So even though you're really sick, if it's just sort of a one-shot thing where you don't have treatment and you just stay home and get better, that's not covered by the FMLA. If the person's parent, spouse, or child has COVID-19, it's going to be the same thing. Maybe it rises to the threshold of FMLA leave of a serious health condition, or in many cases, it will not. But if, for example, the person is really sick and is hospitalized, then it's covered by the FMLA, and the person can take FMLA leave for that. Then you have all the leave that you normally provide under your policies, and many employers are very generous. So paid sick leave, paid vacation, paid personal days, you know, all of those kinds of things. A person can take leave under those and get paid when they're home for something covered by COVID-19. And then we have leaves as an accommodation under the Americans with Disabilities Act. So under the ADA, the first priority is to try to have the employee be able to work, to accommodate them in the workplace so that they can do their job. But if we can't do that, if they aren't able to be accommodated in the workplace, then we look at accommodating them not in the workplace, which can include teleworking, you know, working from home. But if they can't work at all, then leave may be an accommodation. So I'm going to spend the rest of our time before we go to Q&A going through some practical situations and how you would work through all of these things. And so we're going to go from one extreme to the other. We're going to start with somebody who's clearly sick or clearly covered by COVID-19, and then we're going to go to someone who maybe isn't sick at all, but has COVID-19 concerns. So we'll start with the easy ones. If you have an employee who tells you, I have been diagnosed with COVID-19, my doctor says I cannot go to work, that is going to be covered by the special COVID-19 laws that Nhan was describing. That will be covered by the emergency sick leave laws, because the person has COVID-19 and cannot work because they have COVID-19. So similarly, if you are doing temperature checks when someone comes to the door and someone fails the test, so you decide they are, you know, according to the CDC guidance, at risk of being, you know, having COVID-19, and you make them go home, they're going to be covered because you've treated them as if they have COVID-19. They can then take that kind of leave. So that's a pretty easy one. So they use up, as Nhan indicated, they have 2 weeks or 10 working days of leave that they can get paid for under the Emergency Act. Then if they are still sick, they are out of that leave. They don't have that anymore. But they might very well be protected by the FMLA. So if the person was hospitalized, they would, you know, so this is an ongoing illness, it's not, you know, resolved in just a few days, and they're hospitalized, even though they've used up their 10 days, they'll be covered by the regular FMLA. Remember that the regular FMLA is unpaid. You don't get paid for the FMLA. So since it's unpaid, they're either going to not get paid or they're going to be using up their vacation and sick time and those kinds of things. So the easy case is when we know somebody can't work. Now, what about somebody who can't work, not because they are sick, but maybe because they've been exposed to somebody who is sick, or maybe because they've done something that under both the CDC guidelines and perhaps your policies you think is dangerous. So let's say, for example, I travel to Florida for spring break. As far as I know, I'm not sick. I haven't tested positive. I don't know if I've been exposed to anybody who's sick. So I'm not covered by the orders, the rules that say if I'm sick myself, or if I'm exposed to somebody who's sick, then I'm covered by the Families First leave. But I certainly went to a high-risk area, and the CDC would agree that it's a good idea to then make the person quarantine. Well, you can do that. As long as your policies are clear, so I know in advance, if I choose to go to Florida for spring break, this is what's going to happen. You can say you can't come back to work until you're home for 14 days, and we make sure that you're not sick. Well, am I covered by anything during that time? I'm not sick myself. I can't say that I was exposed to somebody who's sick. And I am not under, at this time, an order to stay home. So for a long time, under Governor Whitmer's orders, if we were all quarantined. We all needed to stay home except when we walk our dog and those, get groceries and those kinds of things. And so if we left, then we would be in violation of that order. So here, we don't have those anymore. We in Michigan are allowed to come and go as we want, so long as we, do certain things. So if I decide to go to Florida, you can say you have to stay home. And no, you're not covered by anything that gets you paid. So you can use up your paid vacation time or something like that, but we're not going to pay you to stay home unless you have, paid leave in your bank, because you chose to go do something that could put us all at risk. So in other words, if I showed up at the door the next day and you asked the question, have you been exposed? I wouldn't know the answer, because I went someplace that is high exposure and I have no idea if I've been exposed. So that's a relatively easy situation. The next situation is somebody who isn't sick, but is at high risk of being sick. And they have medical documentation that tells you that. So for example, I have some, immunosuppressant condition where my immune system is not working well, and my doctor says I can't be exposed in these situations. That's medical that you have to take seriously. Now, am I covered by the Families First legislation? Maybe not. I don't have COVID. I haven't necessarily been exposed to anybody with COVID, but I do have a serious health condition, probably under the FMLA, if this is something I've had, regular medical treatment for. I may very well have a disability as described by the ADA. And so I could be entitled to FMLA leave. And if I'm out of FMLA leave or haven't worked long enough to have FMLA leave or something like that, I could be entitled to an accommodation under the ADA. An accommodation could be letting me work from home, or an accommodation could be the leave itself again. Now, ADA does not require indefinite leave. So what if I say, well, so I can't go back to work until there's a vaccine? And my doctor supports that, and we agree I have a serious health condition, we agree I have a disability, and I can't go back work. Well, who knows when that will be? The ADA is very loose on how long you have to give leave. It's until it's an undue hardship. An undue hardship is not a clear definition. What we do know is you don't need to give indefinite leave. So you don't need to say, okay, you can stay off until whenever. So if you have a clear date when they can come back, that's not indefinite leave. We also know that you don't have to give leave when it's an undue hardship. So we have to have kids in school with their teachers. We don't have enough teachers to cover. If we give this person this leave, that will be an undue hardship. So we have to replace them. Then you might not have to give the leave, but that's a process you'll have to walk through. And then the final situation I want to talk about before we talk about the school situation with kids, which is really the hot issue right now, is when the person doesn't have a clear medical condition that obviously would be affected, like a hampered immune system, but has risk factors, and the CDC gives us a list of risk factors. So they're over the age of 65, for example. the EEOC is very clear that you cannot discriminate on the basis of age. And that means not only can't you do something against somebody because of their age, you also can't do something for somebody because of their age. So if I'm not sick, I'm healthy as a horse, but I'm 67 and I say, my doctor says you're 67, that's a risk factor. You can't give me leave because of that. I might have a couple of factors, but if they don't rise to the level of a disability under the ADA, then you're not required to do anything about them. All right, I want to spend the last few minutes we have before Q&A talking about the school situation. And this is something that is facing probably the majority of our population actually right now, like in the next few weeks. And that is, I'm healthy, I don't have any problems, I'm not covered by anything, you know, I don't have COVID, I haven't been exposed to COVID, anybody with COVID, nothing like that. But I have children and my children aren't going to be in school. And so now what do I do? And this is one of the specific things, this is what the emergency FMLA is about, which is when the people that normally would take care of your kids, whether it's a daycare or a school or whatever, they're not available. And somebody who's probably on here, and I don't know who, sent a bunch of specific questions that actually are terrific at walking us through these. So I'm just going to paraphrase them and go through them. So the first one is if there's a go to school option versus a stay at home option. And so the person's kids could go to school. They could choose to have them be in school, but they don't want to. I don't think that meets the test. The test is that the regular care provider, which can be the school, is unavailable. And here it's not unavailable. They could have chosen to go to school. So I think if they want to stay home with their kids, that's not going to be covered. Now, I say that this is, as I said, a really moving target, and we could see some changes on this. But right now, I think if the schools are open and the person could send their kids to school, that's not going to be covered as emergency FMLA. Okay, then we have the situation which is very common, which is school is virtual. It might be full-time virtual, it might be part-time virtual. There's not a legal difference between the two, but there is a period of time where we all agree the school is not available to take care of the kids. That's emergency FMLA. That is covered by emergency FMLA, unless the kid is a high schooler. If the kid is over 14, then you are allowed to say you need to leave your kid home alone, unless the kid has some sort of condition which would suggest that you can't. But if it's just your normal high schooler, they can stay home and school themselves alone. But for younger kids, the person no longer has the care available, and so they would again be allowed to take emergency FMLA for that. What if the child care is available, but the person doesn't want to use it? They're afraid, you know, I want to keep my kids in my house. I'm afraid of exposing my kid to the child care. If it's available and if it's compliant, I mean, there are requirements they have under all these laws as well. But if it's available and it's compliant, again, they can't say it's unavailable. So they're supposed to be at work. What if there's no child care available, but they can telework? Can you tell them, well, you still need to work, but you can stay home so that you can handle your kids, which is what many, many, many people did at the beginning of all of this. And the answer there has to do with the job. If my work is such that I can do it during non-school hours, or if my kid's school situation is such that I can school them at any hour, then that may very well be appropriate, and they could do that, and that would be considered an accommodation of their condition, and that would be fine. On the other hand, if my day job is, you know, a call center, and I'm supposed to be, you know, on call during specific hours, and those specific hours overlap with the hours when my kid is supposed to be, you know, being in school from home, then that won't work. And so now I think that they can say that they don't have the care for their kids that they need available, and they're entitled to take leave for that. So that's a lot of information in a pretty short time. We're happy to answer questions folks might have that put a little bit more meat on some of these bones.
Megan, Nhan, thank you so much. Again, if those that have joined us have questions, please use the questions pane to submit any questions that you might have at this point. We do have one question thus far, and have some time for a few others. So the question that was posed really is maybe a bit of a takeoff on one of the hypotheticals that you just gave, Megan, and it says, If an employee requests remote work due to pre-existing health concerns, but the employee has already shown that they're not successful with remote work, in other words, they're not productive, what would you suggest under those circumstances an employer do?
So that's a really good question. This goes back to just general ADA reasonable accommodation analysis. Working from home is much more prevalent now because we've all been staying home, obviously, but working from home has always been a potential reasonable accommodation. The courts, and especially the Sixth Circuit, which is the appellate court that is oversees Michigan, have been really pretty hardline on this. And there's a pretty famous case against Ford Motor Company that was brought by the EEOC that came out just a few years ago, where the court went for pages and pages and pages saying, you have to be able to go to work. Work means work, and you need to be able to go to work. Now that presumes that the duties are such that they can only be best performed at work. And in that particular case, it was very similar to this question. The company tried letting the employee work from home, and the employee had maybe 10 duties, and they successfully could perform 4 of them at home, but they couldn't perform the other 6 successfully at home. And so the court said, that's not a reasonable accommodation. Working from home is not a reasonable accommodation for you. So I think that if the employee cannot perform the duties at home, then that's not a reasonable accommodation. So let's assume that's the case. It's not a reasonable accommodation. Now the question is whether they need leave. They can't perform their duties, even with accommodation. So do they need leave? And that's going to get into, are they entitled to leave under the ADA? They might be. And then if they are entitled to leave, how much leave? And again, under the ADA, there's, FMLA is a clear hard stop, 12 weeks. That's all you get. But the ADA picks up from there, and you have to, if they need 3 weeks, you're going to probably have to give them 3 weeks. If they need a month and then they need it extended a few more weeks, you're probably going to have to do that. But if each time their time comes up, they get another 1 month extension and the doctor just extends them 1 month, 1 month, 1 month, you don't have to keep doing that. There's a point where you can say, we have no reasonable expectation that you're going to be returning to work at that time. So that looks like an indefinite leave, and you don't have to do that anymore.
Okay, great. I did have another a school hypothetical posed similar to the 4 that you touched on. And this one asks, the local school provides in-person instruction at the start of the school year, but then transitions to online-only education for the month of November, as an example, due to an increase in the number of COVID-19 cases in the area. What would be the legal obligations under those that circumstance?
Right. So we're going to go through the same analysis, and this is the pressure that is really hitting employers hard right now, because a bulk of employees, in other words, at one time, a whole lot of employees are being faced with the same situation and are suddenly unavailable. So if in-school is available, they have to have their kids in school, or they have to have an alternative that is not them. I mean, they can have, a babysitter, take care of their kids from home or whatever, but they're not going to be protected. They're not going to have protected leave if school is available. But then come November, which is what we had last March, come November, when the school is not available, the question will be, is there something else that's available? Can they have, again, a caregiver or something like that? And if the answer is no, the parents are responsible for educating their kids, and they're not going to have some, high schooler come over and help educate their kids. They want to do that themselves. They're probably going to be entitled to leave. Now, as Nhan mentioned, all of these emergency COVID leaves currently end December 31st. The Emergency Paid Leave Act, the Emergency FMLA, end December 31st. So there is a limit on how long somebody's going to be able to stay home and homeschool their kids. And while it's possible that those acts get extended, you've seen we're not having a lot of movement right now. There'll be an election between now and then, but who knows? So right now, I would say if suddenly the schools are closed in November, or they tell you now they're going to be closed in November, there are going to be people who will be entitled to leave. And I think a lot of employers are going to get hit all at once about that.
Great. So some questions keep coming in, so thanks for your continued time. Next question is the FFCRA subject to negotiation with a union?
No. I mean, this is a federal law that is on top of any regular things. It may be that it coordinates with certain union things that you already have. I mean, if what you're giving under the FFCRA, you know, as I said, you can make people use up paid sick leave to supplement their income when there are caps on the certain leaves given by the FFCRA. So if you're allowed under the union contract to make people use up paid leave when they have unpaid status, you could still coordinate in those ways. But the acts specifically say that when the person is entitled to the emergency sick leave, in other words, they themselves have COVID or the family member has COVID or they think they've been exposed to somebody who has COVID, like the family member, when somebody is covered by that, they are entitled to that pay first. So even if they have other pay, you know, through their union contract, they get the new COVID pay before anything else, and that's the 2 weeks pay. It's limited at 2 weeks.
Okay. And the next question is, if a business does not offer sick time, and they gave the example here because they employ less than 50, do they have any obligation under that circumstance to pay sick time?
No. So they have an obligation under the Emergency Paid Leave Act, and there's no exemption for small employers, but there is a permission to be exempt, I guess I would say, for small employers. So in other words, you're covered if you have one employee, but if you have, I think it's 25 or fewer employees, you can request an exemption. But the money, this as Nhan mentioned, this is money that you get back directly in a tax credit. So while you have to pay it, you get 100% forgiveness of that money on your tax credits. So so there won't be a basis for a financial exemption. The basis for the exemption will be, we only have 3 people running our shop. If I lose one person, what in the world am I supposed to do? But frankly, practically, I don't think there's any procedure in place for how you actually get that exemption. And if you figure out the procedure and you go through the procedure, we will be at December 31st by the time, you know, all of that happens. So generally right now, all employers are covered until actually really big employers. So if you're, for example, a big school district, if you have more than 500 employees, you're not covered. But that's because you already, more than 500 employees, generally you have lots and lots of leaves that you're already, you know, providing in lots of ways. And so it's a little bit different for those employers.
Okay. The next question is, if an employee is asymptomatic after a direct exposure, can an employer require the employee to take a COVID test? Is a testing requirement subject to negotiation?
Good question. I'll do the second one first because that's probably easier. I think a testing requirement would be subject to negotiation. I mean, it would depend on what your contract says and whether something like that is already anticipated. There may be something in the sick leave policies that you already have, and those sorts of things that already provide for testing for certain situations, and this may just be one more situation. So it may already be dealt with. But if it hasn't been, I think that would be subject to negotiation. The bigger question about whether you can require a test, this is a real moving target. At the beginning of COVID, the answer was absolutely not. And the reason was that tests were really hard to come by. Doctors were really hard to come by, much less tests with doctors. And so it was clearly stated that you could not require somebody to be tested. In fact, you couldn't even require a doctor's note. If they had the symptoms, you needed to keep them home. Testing is much, much easier to come by now, although getting results from the testing is not so easy. At least in a timely manner. And I think we're at the point where testing probably can be required absent some exception like that we always have with medical issues, like a religious exception or something like that. What we've been advising our clients in this situation is, yes, you can require a test, But if the person has some exception, some reason why they can't undergo the test, then you can make them stay home for the amount of time that the CDC says somebody who is potentially has COVID or is potentially exposed needs to stay home. And Nhan knows the details of that. That one changes every day as well. So Nhan, how many days and for which fevers and which things now do they get to stay home?
So it is 10 days from the time of the onset of the symptom or when you swab for the test. And then in 24 hours with no fever, without the use of fever suppression medicine, and then all the other symptoms has improved. So all the three categories can be met.
So in other words, you need a certain amount of time since you've been exposed or since you've gotten sick. You need to not have any symptoms, and you need your fever to have been gone for a certain amount of time. And so you could make the person stay home if they refuse to get tested for a reason that you might have to honor, like a religious reason. Then you can make them stay home.
Another question, if an employee's spouse has COVID symptoms, but it's not been confirmed by a doctor because that spouse already works remotely, so there's no reason for a test, how does your employee proceed? Being that they're potentially exposed to COVID, are they covered by any leave for the days that they stay home?
Yeah, so if my husband comes home and we have reasonable belief that he has COVID, he has the COVID symptoms, he's called his doctor on his phone and the doctor has said, treat it like you have COVID. I am now presumed exposed to a person with COVID. So if I came in the morning and you were screening me and you said in the last 14 days, have you been exposed? The answer is yes. I mean, I don't have a positive test, but he's being treated like he has COVID. Therefore, I'm being treated like somebody who's exposed to somebody with COVID. And now I'm going to be protected under the family's first medical leave that covers people who themselves have COVID or who have been exposed to somebody with COVID. And so I will get those benefits.
Another question asks, does an employee qualify for FFCRA leave when living with someone that is in the process of getting tested for COVID? Apparently, a lot of healthcare providers are asking that all family members quarantine, but some are not.
So I'll tell you what I think, but Nhan, I'm going to defer to you if you think I'm wrong. I don't think living with someone is treated any differently than a spouse or a family member, first of all. I mean, I think if you're all in the same household, I think that will be treated the same way. I think that there is a difference between testing positive for COVID, believing that there is COVID because you have the medical symptoms that make you think that you have COVID, and just worrying that you might have COVID. I think those are three different things. So if the person in the house tested positive, I think you're into the exposed with someone with COVID, realm. And so then you're protected. If the person in the house has COVID symptoms and the doctor has said, treat yourself as if you have COVID. In other words, I can't get you in for the test, or by the time we get the results from the test, it'll be too late. Or just act like you have COVID. Then I think the person that's exposed to them living in the house, again, would be treated like someone who's exposed to COVID. And if the person just thinks they might have COVID because they went to the store and people weren't wearing their masks and so they're worried, or that probably doesn't rise to the level of being exposed to somebody with COVID when there are no symptoms. Nhan, does that sound about right?
Yes. So I agree with Megan. That you are tested for COVID. Your doctor tells you that you need to self-isolate because you might have COVID, and then they just general believe that you have COVID. Those three things need to be treated differently, especially the last one, because it's not covered under the FFCRA. But the first two would be covered. And then I just want to add that if you have a family member who had COVID or who has been told by a doctor to self-quarantine for COVID and you need to take care of them, that's also a qualifying reason for the paid medical leave.
Right. So even if I don't live with my parents, for example, if my parents either test positive or are told quarantine because it's likely you have COVID and they are sick, not just that they've been exposed to them, but they're sick and they need help, I could take leave for them.
Okay, picking up kind of on that theme, what if your spouse is waiting for results from their COVID test? Does the household have to quarantine at that point?
If they got a test because there was some reason to believe that they might have COVID, in other words, they had symptoms, so they went and got a test or something like that, I would say yes. If they got a test just because a lot of people are getting tested, they just, in Detroit, everybody can get tested. And they're being encouraged to be tested. Or because, for example, you're going to have a medical procedure. So before you go to the hospital, they want to make sure, that you're COVID free or something. If there are no symptoms, you're not being tested for symptoms, you're just being tested as precaution, then I don't think the people around you have that kind of protection. But if you were tested because you have symptoms, I think everybody has to treat you like you have COVID, which means the people around you have to treat it as being exposed to somebody with COVID. Go back to your screenings, so all employers now are doing these screenings and they're all pretty similar. And what are the questions? Questions are, have you tested positive? No. And then have you had any of these symptoms? So if you have a fever, if you have a cough, if you have those symptoms, you're being sent home. The minute that happens, you're triggering rights under the act because you're being treated like you have COVID. You're taking the precautions as you have COVID. And you're not just sending everybody home, you're sending people with specific COVID symptoms. And then I think the people who are exposed to them are similarly going to be protected until it's determined they don't have it. So let's say I have symptoms, you send me home, my spouse is sent home, I get the test, and the test is no, you don't have COVID, you just have a sore throat or you just have, whatever. Now my person that's connected with me, they're not protected anymore either. I mean, we've ruled out COVID, so we're just into regular sick people.
So we're right at 10 o'clock. I want to be mindful of your time and gosh, the generous commitment that you've made to us. There are a few more questions and we could either follow up possibly with you to answer those, or if you have a minute or two yet, although it might be 3 or 4, we could work through those quickly. So I look to you wanting to be real sensitive to the commitment that you've already made, Megan and Nhan.
Why don't we take the ones we have, but not take any more?
Great, that's perfect. So we'll work through these last 3. There were a couple on masks that are, I think, a little outside the intended area here.
That's okay.
So let me just work through these. And the first asks, how can an employer determine if they are considered critical infrastructure and therefore not subject to FFCRA?
So that one is defined by the governor's order. The governor's order lists what's considered critical infrastructure. It includes certain kinds of manufacturing, various healthcare, things like that. And it's not entirely concrete. It's open to some interpretation, but it's pretty concrete. So Nhan, what is it? Is it the CDC that also lists critical infrastructure, or is it is it OSHA? There's also national list of critical infrastructure.
Yes, it is I don't remember the exact agency, but there's a federal guideline of what employee would be considered critical infrastructure, and that what Michigan based on. But I'd like to add to what Megan said, the FFCRA provide exemption not for all critical infrastructure employee. It only provides exemption for public health, like healthcare provider and healthcare provider and emergency responder from the leave. All other critical infrastructure that doesn't belong to those 2 categories still cover under FFCRA.
Yeah, so it's a little tricky because the governor's order is not entirely consistent with the federal guidelines. And one of the issues is, let's say you're in manufacturing, our governor initially did not have manufacturing as critical infrastructure. She eventually allowed manufacturing to go back to work, but manufacturing was not critical infrastructure. But if you're part of a supply chain, so you're an auto parts manufacturer here in Michigan, and your supply chain is down in North Carolina, and North Carolina is not closing the doors at all, and you're getting a letter from your client that we consider you critical infrastructure because here are your critical infrastructure, then you were allowed to keep operating. because you're part of that supply chain. So it is a little bit tricky. I think that's becoming less and less of an issue as the doors are opening. I mean, it's the rule now in Michigan is if you can stay home, you still have to stay home. So I'm a lawyer, Nhan's a lawyer. We're not used to working from home, but we've been working from home since March, so we can still stay at home. So therefore, we have to still stay at home. But if you can't do your work from home now, and many places can't do their work from home, now you're allowed to go, whether you're critical infrastructure or not.
So the next question asks, if an employee stays home in compliance with Executive Order 166, which requires people to stay home under certain circumstances, would this be eligible for FFCRA leave?
That's a non-question.
Okay, so under the executive order, you have to stay at home if you are tested positive for COVID-19, you have symptoms of COVID-19, or you come in close contact with COVID-19. This is just my belief, but there has no guidance there. I believe that the order tell you that you have to stay at home. That is an order that is covered under the FFCRA, and leave would be available at that point. But you definitely should assess the situation. What amount of leave that they have, all of that, in order to consider whether they should be provided for leave. If leave are not available under the FFCRA, you still have to let them stay at home, but at that point, it's no longer FFCRA leave. It's just unpaid leave until they can return.
Right.
So 2 final questions, ladies. They may be a bit outside your areas of expertise. I'll ask them both and let you then respond accordingly. So the first is, we have a counter for transactions at my business. We offer masks, or we require masks to enter. Am I required to have a plastic barrier at the counter as well?
Maybe answer that.
So the answer is that each state, I think, is a little bit different. Here in Michigan, the governor has issued pretty clear direction about what stores, for example, needed to do to be open. And that has changed. If you just think about when you first went to the grocery store during COVID, it was exactly the same as usual. When you next went to the grocery store during COVID, they might be wearing masks. And then when you went to the grocery store, they had arrows on the floor, and they had plastic shields and all of those kinds of things. So it's going to depend on the size of your establishment and your resources. I mean, there's a bit of a sort of do the best you can do kind of thing. But for major operations, the standard of care, if you will, is plastic shields. If you're I was just in Vermont, and if you're the gas station that is the only gas station within 150 miles, and you're just sitting on a corner all by yourself, and it's one guy behind a desk, he did not have a plastic shield. He just took like a plastic sheet and hung it down, like a curtain. That's probably fine. But yes, all of the major stores, all of the major operations are required to have certain safety precautions in order. And many of those, in fact, I say most of those are in the OSHA guidance, which talks about, safety in the workplace and specifically safety in light of COVID.
And we've been fortunate to have Director Egan join us a couple times, and has been very helpful in that regard. So we're glad to follow up with those types of questions if any of those that are listening have some additional questions. Lastly, it asks for some advice, if you might have any. An employee's doctor stated an employee cannot wear a mask while at work. The employer's work environment doesn't allow for social distancing, and they cannot provide other accommodation. Secluded areas, new positions, telework, etc. The employee hasn't given any suggestions either on accommodations, so they're wondering if you might have any advice under those circumstances.
Yeah, so that's a really hard one, and that's a good question. So first of all, the current guidance does anticipate that there will be people who cannot wear masks, and it allows that. So in other words, I could go to the grocery store without a mask under certain situations. You could have somebody in your workplace without a mask under certain situations. I think, and this is my sort of reading of the gestalt of the whole thing, The idea is if everybody else is doing what they're supposed to be doing, so everybody else is social distancing, everybody else has barriers where they need barriers, everybody else has PPE if they need PPE, everybody's wearing masks, having one person without a mask will not affect anything. In other words, that person is breathing on people with masks, and the people with masks are breathing with masks. And so there shouldn't be any contamination, and that should be accommodated. I can envision situations where that's untenable. I can envision situations where they have to be really in close contact, not 6 feet apart, but you know, if you're working on a manufacturing line where the two people on each side of the line are you know, face to face, and there's nothing that you can do to limit that, for example, I can envision situations where you'd say that's not acceptable. We can't have the person here without the mask. But as I read the current guidance and the current regulations, they anticipate that there will be a very limited number of people who really truly cannot wear a mask. But if everybody else is doing everything they're supposed to be doing, that can be tolerated.
Well, Megan, Nhan, we kept you about 10 minutes longer than we expected and have gotten through all the questions that were asked. So gosh, so appreciate your time and your expertise. I know Carol Lundberg has joined with you as well and has been behind the scenes, and we greatly appreciate her efforts as well. And again, so thankful that Mike McGee has been such a resource to us through this time also. So thank you so much for joining us and bridging the gap beyond just the Mackinac Bridge and bringing you up to the peninsula. So
we're happy to help.
thank you so much.
All right.
Have a blessed day.
You too.
Bye-bye.